The Ucc Connection. GR text plus smaller text. Forward. This is slightly condensed, casually paraphrased transcript of tapes of a seminar given in 1990 by Howard Freeman. It was prepared to make available the knowledge and experience of Mr. Freeman in his search for an accessible and understandable explanation of the confusing state of the government and the courts. It should be helpful to those who may have difficulty learning from such lectures, or those who want to develop a deeper understanding of this information without having to listen to 3 or 4 hours of recorded material. The frustration many Americans feel about our judicial system can be overwhelming and often frightening, and like most fear, eventually, with the seemingly tyrannical power of some governmental agency and the mystifying and awesome power of the courts. We have been taught that we must get a good lawyer, but that is becoming increasingly difficult, if not impossible. If we are defending ourselves from the government, we find that the lawyers quickly take our money, and then tell us as the ship is sinking, "I can't help you with that, I'm an officer of the court." Ultimately, the only way for us to have even a snowball's chance is to understand the rules of the game, and to come to an understanding of the true nature of the law. The attorney lawyers have established and secured a virtual monopoly over this area of human knowledge by implying that the subject is just too difficult for the average person to understand, and by creating a separate vocabulary out of English words of otherwise common usage. While it may, at times, seem hopelessly complicated, it is not that difficult to grasp. Are lawyers really as smart as they would have us believe? Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers learn about procedure, not about law. Mr. Freeman admits that he is not a lawyer, and as much, he has a way of explaining law to us that puts it well within our reach. Consider also that the framers of the Constitution wrote in language simple enough that the people could understand, specifically so that it would not have to be interpreted. So again we find, as in many other areas of life, that the buck stops here. It is we who must take the responsibility for finding and putting to good use the truth. It is we who must claim and defend our God-given rights and our freedom from those who would take from us. It is we who must protect ourselves, our families and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skill and talents of others. To these ends, Mr. Freeman offers a simple, hopeful explanation of our plight and a peaceful method of dealing with it. Please take note that this lecture represents one chapter in the book of his understanding, which he is always refining, expanding, improving. It is, as all bits of wisdom are, a point of departure from which to begin our own journey into understanding, that we all might be able to pass on to others greater knowledge and hope, and to God, the gift of lives in peace, freedom and praise. I send you out as sheep in the midst of wolves, be wise as a serpent and harmless as a dove. Introduction. I was asked to testify in a tax case as an expert witness. After many days of preparation, I felt confident of my research. I spent over 30 minutes presenting many Supreme Court decisions that supported the defendant's position. The prosecution concluded his statements, and to my amazement, the judge told the jury that they could only consider certain facts, none of which were the facts I had given. As soon as the trial was over, I went around to the judge's office and he was just coming in through his back door. I said, "Judge, by what authority do you overturn the standing decisions of the United States Supreme Court? You sat on the bench while I read that case law. Now how do you, a district judge, have authority to overturn decisions of the Supreme Court?" He says, "Oh, those were old decisions." I said, "Those are standing decisions. They have never been overturned. I don't care how old they are, you have no right to overturn a standing decision of the United States Supreme Court in a district court." Public law v. public policy. He said, "Name any decision of the Supreme Court after 1938 and I'll honor it, but all the decision you read were prior to 1938, and I don't honor those decisions." I asked what happened in 1938. He said, prior to 1938, the Supreme Court was dealing with public law. Since 1938, the Supreme Court has dealt with public policy. The charge that Mr. S was being tried for is a public policy statute, not public law, and those Supreme Court cases do not apply to public policy. I asked him what happened in 1938. He said that he had already told me too much, he wasn't going to tell me any more. 1938 and the Erie Railroad. Well, I began to investigate. I found that 1938 was the year of the Erie Railroad v. Tompkins case of the Supreme Court. It was also the year the courts claimed they blended law with equity. I read the Erie Railroad case. A man had sued the Erie Railroad for damages when he was struck by a board sticking out of a boxcar as he walked along beside the tracks. The district court had decided on the basis of commercial negotiable instruments law that this man was not under any contract with the Erie Railroad, and therefore he had no standing to sue the company. Under the common law, he was damaged and he would have had the right to sue. This overturned a standing decision of over 100 years. Swift v. Tyson in 1840 was a similar case, and the decision of the Supreme Court was that in any case of this type, the court would judge the case on the common law of the state where the incident occurred, in this case Pennsylvania. But in the Erie Railroad case, the Supreme Court ruled that all federal cases will be judged under the negotiable instruments law. There would be no more decisions based on the common law at the federal level. So here we find the blending of law with equity. This was a puzzle to me as I put these new pieces together. I determined that all our courts since 1938 were merchant law courts and not common law courts. There were still some pieces of the puzzle missing. A friend in the court. Fortunately, I made a friend of a judge. Now you won't make friends with a judge if you go into court like a wolf in black sheep country. You must approach him as though you are the sheep and he is the wolf. If you go into court as a wolf, you make demands and tell the judge what the law is, how he had better uphold the law or else. Remember the verse, I send you out as sheep in wolf country, be wise as a serpent and harmless as a dove. We have to go into court and be wise and harmless, and not make demands. We must play a little dumb and ask a lot of questions. Well, I asked a lot of questions and boxed the judges into a corner where they had to give me a victory or admit what they didn't want to admit. I won the case, and on the way out I had to stop by the clerk's office to get some papers. One of the judges stopped and said, "You're an interesting man, Mr. Freeman. If you're ever in town, stop by, and if I'm not sitting on a case we will visit." America is bankrupt. Later, when I went to visit the judge, I told him of my problem with the Supreme Court cases dealing with public policy rather than the public law. He said, in 1938, all the higher judges, the top attorneys and the U.S. attorneys were called into a secret meeting and this is what we were told. America is a bankrupt nation, it is owned completely by its creditors. The creditors own the Congress, they own the executive, they own the judiciary and they own all the state governments. Take silent judicial notice of this fact, but never reveal it openly. Your court is operating in an admiralty jurisdiction, call it anything you want, but do not call it admiralty. Admiralty courts. The reason they cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under the common law. In admiralty, there is no court which has jurisdiction unless there is a valid international contract in dispute. If you know it is admiralty jurisdiction, and they have admitted on the record that you are in admiralty court, you can demand that the international maritime contract, to which you are supposedly a party and which you supposedly have breached, be placed into evidence. No court has admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb, well, I didn't know that I got involved with an international maritime contract, so, in good faith, I deny that such a contract exists. If this court is taking jurisdiction in admiralty, then, pursuant to Section 3 to 501 of your UCC, presentment. The prosecutor will have no difficulty placing the alleged contract into evidence, so that I may examine and possibly challenge the validity of the contract. What they would have to do is place the national debt into evidence. They would have to admit that the international bankers own the whole nation, and that we are their slaves. Not expedient. But the bankers said it is not expedient at this time to admit that they own everything and could foreclose on every nation of the world. The reason they don't want to tell everyone that they own everything is that there are still too many privately owned guns. There are cooperative armies and other military forces. So until they can gradually consolidate all armies into a world army and all courts into a single world court, it is not expedient to admit the jurisdiction the courts are operating under. When we understand these things, we realize that there are certain secrets they don't want to admit, and we can use this to our benefit. Jurisdiction. The Constitution of the United States mentions 3 areas of jurisdiction in which the courts may operate. Common law. Common law is based on God's law. Anytime someone is charged under the common law, there must be a damaged party. You are free under the common law to do anything you please, as long as you do not infringe on the life, liberty, or property of someone else. You have a right to make a fool of yourself provided you do not infringe on the life, liberty, or property of someone else. The common law does not allow for any government action which prevents a man from making a fool of himself. For instance, when you cross over the state lines in most states, you will see a sign which says, "Buckle your seat belts, it's the law." This cannot be common law, because who would you injure if you did not buckle up? Nobody. This would be compelled performance. But common law cannot compel performance. Any violation of common law is a criminal act, and is punishable. Equity law. Equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So, if you have compelled performance, there must be a contract somewhere, and you are being compelled to perform under the obligation of the contract. Now this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of a contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court, which is a criminal action. Are our seatbelt laws equity laws? No, they are not, because you cannot be penalized or punished for not keeping to the letter of a contract. Admiralty maritime laws. This is civil jurisdiction of compelled performance which also has criminal penalties for not adhering to the letter of the contract, but this only applies to international contracts. Now we can see what jurisdiction the seatbelt laws, all traffic codes, etc. are under. Whenever there is a penalty for failure to perform, such as willful failure to file, that is admiralty maritime law, and there must be a valid international contract in force. However, the courts don't want to admit that they are operating under admiralty maritime jurisdictions, so they took the international law or law merchant and adopted it into our codes. That is what the Supreme Court decided in the Erie Railroad case, that the decisions will be based on commercial law or business law and that it will have criminal penalties associated with it. Since they were instructed not to call it admiralty jurisdiction, they call it statutory jurisdiction. Courts of contract. You must ask how we got into this situation where we can be charged with failure to wear seatbelts and be fined for it. Isn't the judge sworn to uphold the Constitution? Yes, he is, but you must understand the Constitution, in Article 1, Section 10, gives us the unlimited right to contract, as long as we do not infringe on the life, liberty or property of someone else. Contracts are enforceable, and the Constitution gives 2 jurisdictions where contracts can be enforced, equity or admiralty. But we find them being in statutory jurisdiction. This is the embarrassing part for the courts, but we can use this to box the judges into a corner in their own courts. We will cover this more later. Contracts must be voluntary. Under the common law, every contract must be entered into knowingly, voluntarily, and intentionally by both parties or it is void and enforceable. These are characteristic. It must be based on substance. For example, contracts used to read, for $1 and other valuable considerations, I will paint your house, etc. That was a valid contract. The dollar was a genuine, silver dollar. Now, suppose you wrote a contract that said, for one Federal Reserve note and other considerations, I will paint your house. And suppose, for example, I painted your house the wrong color. Could you go into a common law court and get justice? No, you could not. You see, a Federal Reserve note is a colorable $1, as it has no substance, and in a common law jurisdiction, that contract would be